It's March 21st, 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. I've got a weird compilation of cases for you today. First, we have a mermaid who is accused of impersonating her former employer and stealing clients. Then there's a $17,000 child support showdown in front of Judge Ricke and a defendant who tried to hide from the law for a year facing Judge DiSanto. Finally, we'll see one influencer take the tech giant Meta to small claims court for $10,000 after the AI algorithm killed his business. It's a week full of sabotage and payback, so buckle up, kids. Grab some popcorn. It's going to be a good one. And it all starts right now.
Thank you. Please be seated. Good morning, everyone. Thank you for being here. I'm here to cover a conflict case. And let's see. I see respondent Tiffany Hagen on Zoom platform and Miss Malone. You want to come to the council table, please? Have a seat, please. So Ms. Malone, Commissioner Stillwell gave information to all parties regarding the court protocols today and the court's expectation and definitions of harassment and then how the court proceedings will work. I see that in your case, let me try to still pull this. Case is 26000056 for no contact order. I see that you filed your petition on February 24th and subsequently Ms. Hagen was served. Ms. Hagen, you want to turn on your video, please?
Yes, Your Honor. Thank you.
Okay. Good. Do you say your last name is Hagen?
No, sir. It's pronounced Hagen, and it's misspelled in the document.
Okay. So is it with two G's?
No, sir. It's misspelled in the document. It's Hagen, Hagen.
Okay, correct that. Okay, so now that Mr. Hagen has been served, Ms. Malone, are you ready to proceed with your petition?
Yes, sir.
Okay. Do you both want to raise your right hand? Ms. Hagen also. Do you swear from the testimony that you'll be giving today will be truth, whole truth, and nothing but the truth?
Yes, Your Honor.
Okay.
Yes, Your Honor.
The petitioner first. Go ahead, Malone.
For a start, I just know that Ms. Hagen has been kind of harassing me continually through third party, through other vendors, and I have a Mermaid School that I run, and she has been using my name and telling these potential people that I've already been talking to that she is running my, I want to say promotions is the word I'm looking for, trying to get us gigs when that's not, in fact, she's not an employee. She's just somebody that I had as a friend helping out, and that's how she paid for her certification, is by kind of helping me out when I certified her as a mermaid. And I heard from several vendors that I had been in contact with that she went behind my back and told them that she was setting up the gigs for us and got the gigs in her name. And then I went to contact them and they're like, oh, well, we already get, when I said, hey, I haven't heard from you about this gig. Oh, well, we already gave your company the gig. And I'm like, no, I'm the owner of the company. And they go, well, we gave it to Miss Hagen. And I was like, it was Rose Downs is what they said. And I'm like, but she's not an employee.
So give me a little bit information on what this company is that you're referring to.
I run a mermaid school.
Mermaid School.
Yes.
How does that work?
I'm certified through the Professional Association of Diving Instructors. I'm required to have a business license and my own insurance. They require all that. Aside of I work for the YMCA, so they have insurance on me, but I have to provide my own and the business license. And when I go and try and get gigs at Renaissance festivals and fairs and private gigs and such, and if they come to me and say, somebody comes to me and say, hey, I need a couple mermaids for this show, I will go to my community of mermaids and mermaids that I have certified. And I will say, okay, this person's looking for this in particular. I gave them a bunch of pictures, their backgrounds, and I will be like, they picked you and they picked you. And I will say, this is what I'm offering to pay you, as the owner of the company. And if they accept it, great, we set it up. And then they are paid through my company to do, I'm going to say like a 1099. They're their own contractor, but because they're not a full employee. And I just set it up to where they're doing the gig because certain people are looking for certain types of mermaids and I may not be their type. They may want a long-haired, as Tiffany, redhead. They may want a really skinny person. They want a man who I have a few mermen on my roster that I can use. So we get these gigs. Well, I've heard back from a few companies that Miss Hagen has gone, after I've contacted these people, has gone in and said, oh yes, I'm working for Ono Wahine, which is my company, and I'm trying to get these gigs set up. And then she's booking the gigs for herself privately and getting paid privately through these companies. One of them was the Thurston County Fairgrounds.
Was in your employ as
she was not an employee ever. She was just a volunteer.
Okay.
Just somebody that came in as a volunteer. And we had an agreement that she would volunteer and help me out as payment, kind of like I do certifications for mermaid certifications through Patty. And in order to get her certification, she kind of like, I'm going to say, just kind of volunteered her time to help me out. And I just kind of comped what my fee would be. And she paid the Patty portion because Patty has their own fees to do the certification papers. So she just kind of helped me out. Yeah. But she was never a paid employee. And I never said she was. And I didn't, she was going out getting gigs for these, supposedly getting gigs for these people. She would, I guess, send them letters in my behalf, which I've never seen the letters. I never approved of any letters. I've been contacting these companies and there's a couple that we have lost out on because she has gone behind my back using my information. And now my name is blacklisted because of that. So I'm losing money because, and I'm losing gigs, professional gigs, because I have somebody using my name saying that oh yes, this is Ona Wahine, she's insured, and they're getting the gigs for themselves under my name. So when the lady at the Thurston County Fairgrounds, when I contacted her, she was under the understanding through Tiffany that she worked for me, but she didn't. So she gave her the gig, assuming that it was my company, with the assumption that it was my insurance, my business license, but I had no knowledge. And after I talked to Kristen personally, because I don't like dealing with text and email, I said, let me call you. Let's explain the situation. Let's see what's going on. I said, please contact me as I'm the business owner. I don't want you dealing with somebody else that's not an employee. So she started dealing with me direct. And that's when she explained to me that Tiffany had gone to her and used my name, used my company to get herself a gig for tomorrow, actually. And
So your company, where is that company located? Is that in your?
my company home is based in Rochester, but I am based at the YMCA, at Briggs YMCA. I work for the company and I run my school through them. And I run my school through all of Washington.
So your allegation that she was using your name to get those gigs.
Correct.
Were those, which county were those in?
It's been Thurston County and what is Seattle, Pierce County, because it was the aquarium up there.
Okay.
Grays Harbor County with Graves Haven Renaissance Festival, the Portland Zoo also. These are different companies that the Children's Museum downtown, the Yacht Club downtown, the Grays Harbor Boat Festival, and the Grays Harbor, the one we did, Harbor Days.
So you're saying that she used your company's good name, your insurance information, and then got basically the contracts for her.
It was trying to get them for her. She got a couple for herself, and then I lost out on the others because of all the drama. They didn't want to deal with us.
Did you contact law enforcement for your identity being used?
I had tried to, but they said I had to just do this. So I contacted them and they said, well, there's nothing we can do. It's a civil matter. So that's why I took it to this. One of my mermen has been harassed continuously as third party because of this whole issue. He's here with me as a witness.
So when you're referring to a mermaid, you're referring to a person,
A human being,
that,
yes.
that human being that acts like that for an exhibition?
Correct.
Okay.
Yes, for shows, for right now we're doing a show at the Mermaid Museum and we're there.
So you said that you have just made their allegations that she has used those. Are there any documentation to prove
The document that I have from the Thurston County Fairgrounds is the text that I received that says that, because I didn't have, like I said, I talked to her in person because I wanted to know what's going on. And I don't like the paper of, like with texting, things get misconstrued. So I wanted to physically talk to her and say what happened. You know, it's easier for me to say on paper and it's just somebody says, oh, well, that's not what it was. It's easier for me to talk to somebody in person. The lady at the fairgrounds has letters that says she's calling Rose to discuss it, send her information, and that she's said that somebody was threatening her, but there wasn't a threat to her. It was Mermaid Orion. The only threat was, if you don't leave us alone and stop using my information, you will be sued. That was the threat.
Who made that threat to who?
Orion. And so she wanted to clearly speak to me before, and I was working, so I didn't get the message. And then it came back that I said, from using my business name to gain jobs, the casino, etc. I'm trying to find the one that she says, I will give you a call. And that's when I physically talked to her. She goes, her one thing is, by the way, I received a visit from Rose on Monday at work. Oh, this was me. She visited me at work without my permission while I was teaching. And she showed up trying to discuss everything that was going on. And her stating that you and her talked almost daily and you two are very good friends. I said I had purposely not responded to any text. I wanted it to go away. I wasn't trying to do any of this. I just wanted her to leave me alone. Leave my business alone, leave me alone, leave. She's hurting my business. I just wanted it to be gone and be done. So I ignored her. She showed up at my work. I almost got fired because she also sent threatening letters she sent under different names. She sent letters to the YMCA about the letters that Orion said about protecting me, leave me alone. And I almost got fired because they thought I was involved in it. And so I got called in the office and they said, do you know what's going on? And I explained, I said, because we've received several letters regarding some things that are really disturbing. And I said, and before they even told me who it was, I said, let me guess.
either Rose Downs, Mermaid Lava, or Tiffany Hagan? And he looks at me and goes, yes. And I said, it's the same person under 3 different aliases. And that's what she's been doing to these different companies, is going under different aliases, using my information, trying to get jobs, showing up at my work, contacting multiple mermaid friends of mine. One I have a letter from that she immediately contacted her and was harassing her. It's like, now I have to step back as a friend because of things that are going on. And I don't want her contacting the people that I work, you know, mermaids that I've used in the past, or any of my people that I know that are mermaids that I could say, hey, I might want to use you for a gig. You know, they aren't going to want to work with me because of all the harassment, because it was constant emails and texts and phone calls back and forth. I never went to anybody when there was an issue. I was just trying to let it go and leave it alone. I didn't go to my friends. I didn't go to Orion. I didn't go to anybody. I just let it be. I started getting all these phone calls from all these different people, including the lady at the fairgrounds, saying, what is going on? Why are we getting all these harassing phone calls and constant texts, and from Orion and Mermaid Koi and Mermaid Jess and the lady at the fairgrounds and Grace Haven? They were getting all of these messages and all of these emails, my work.
When you're saying they were getting, it's the third parties, other
The
people.
third party. And they aren't going to want to work with me because they're being harassed about a situation that had nothing to do with them. If that makes sense, if they're being harassed about me through them, they're not going to want to work with me, which is hurting my business. I'm losing jobs. That's my income. I've already lost out with the Seattle Aquarium. Will not work with us anymore because of this issue. The Portland Zoo, the Children's Museum downtown, which I have worked there before, the Yacht Club, the Boat Festival, Harbor Days, and the fairgrounds. And I finally got that one straightened around where I might have a gig, but I did lose out on a different gig with her because of Tiffany. I can't be harassed. She also has been stalking me and Orion Bolt on Facebook. She blocked everybody as soon as everything happened and she got served. She blocked everybody. She turned down her social media. Nobody, everything's done. Everybody was blocked. She can find me. She can unblock for a minute, find me, and then reblock. I don't go into her stuff, so I have no idea what's going on. I don't care what she does. I just want her to leave me alone. But she found out that my father died. I didn't tell her. And she's going around telling other people.
You told me in your protection order.
And I didn't say anything. My father was sick. But I never told anybody except for I made a post on my Facebook that said, you know, my father has passed. So the only way that she would know personally is if she was stalking me and going through my stuff to find that out. Because I'm not telling her, I wasn't talking to her.
You said she turned off her media and she
all of her social media got turned down. Her Instagram, her Facebook, her
How is her blocking her social media as in harassment to you?
No, I didn't say that was harassment. I'm just saying that she turned it off as she didn't want me to see what she's posting. I don't know if she's posting bad things about me. I do know that she's going to everybody and telling them personal stories about what she believes that she wants to believe about the company. I'm not going to these people. I'm not going to anybody. They're messaging me or calling me and saying, what is going on? This Tiffany person has been constantly calling me and texting me, and they're like, I don't want to be involved in this. And I'm like, I don't want you to be involved in it. I don't know. I didn't say anything to them because I didn't want this to escalate into this. I just wanted it to disappear. So I had, like I said, I had ignored her for 3 days after I found out what she did at the fairgrounds. And then I found out with I started calling and saying what's going on to these different festivals. And they told me what was going on with her using my name and using my company name and saying that she had the insurance and that we were covered. And I'm like, I don't think that's okay. It hurts my
Earlier
business.
You mentioned, you said that she has been stalking you. Can you give me examples of how she was stalking?
She's been telling everybody about the incident on New Year's. There was her and another mermaid worked the New Year's gig at the Tilley Casino. And there was an incident and I was there the entire time supervising. So I had two mermaids and me standing in between, watching everything that is going on. This is New Year's Eve. This is at a casino. People are extremely drunk and our mermaids are wearing tails and they're put in chairs almost in a pathway. One of the men that was extremely drunk came in, tripped over her tail and fell on her. He got up, he apologized. She told me what happened. I had eyes on her the entire night. I was over there helping. We also had another man come over and stand next to her to help escort people around her. I talked to security. I informed them of what happened. My other mermaid that was there was a witness that happened one time. When I confronted her, I asked her about it. And because Tiffany was causing drama towards what was going on with the other mermaid, just kept spam texting her and calling her after the event. And I had thought I had taken care of the situation. I was literally there the whole time watching the whole event. Nothing else happened. After the event was over, she contacted the event director instead of coming back to me and said it happened several times. I knew about the one incident. I took care of the incident. And that was it. It was done. I informed the security. I assume the security informed the event director because of what happened. Apparently that didn't happen. So I contacted the event director. The event director had told me that Tiffany had gone to her behind my back and told her that it happened several times, which in fact it didn't. I was there the whole time watching, so I knew it didn't. And said, well, I'm not going to press charges, or I'm not going to sue. And she ended up getting a free night stay and some gambling money from it, from what I understand. It kind of like, I want to say extortion's not the word I'm looking for, but she went to that person and then took it to the other, to Mermaid Koi, who had nothing to do with New Year's, absolutely nothing. She had messaged her, and that's in here. That Koi had just sent me a little an email that said what happened. She blocked Rose because she kept getting harassed by her. She did say that. She wouldn't stop calling and texting her about the incident on New Year's that had nothing to do with her. Mermaid Jess, the other mermaid that was there New Year's, kept getting texts and calls from her, and she wants to stay Switzerland. She said, she goes, I saw the one's incident, never happened again. I don't want to be in the middle of any of the drama. I just want to stay out of it. I respect that. I don't want my business to suffer, and it has.
Thank you. I understand your position now. I may have few more questions, but let me hear from Ms. Hagen now.
Okay, I do have my witness if you have any questions for him. He did do some police reports about the stalking and
You have explained enough. I don't see any reason.
Okay, but I wanted to give that option if it was necessary.
Thank you, Ms. Malone. Ms. Hagen, go ahead.
Hello, Your Honor. So in June of 2025, I became an affiliate with the Port of Olympia. I decided one day while walking around the harbor with my family, we needed some kind of children's entertainment down at the port, and I believed that mermaids would be a great, accessible, entertaining event for parents to come to. It would be a great opportunity for families of low income to have access to quality educational entertainment in our city for free. I met with the Port of Olympia's market managing and advertising guy. His name's Tabor Lee. We decided that if I could find someone who had the equipment to throw a mermaid show at Olympia Harbor Days in August of 2025, that the city would allow me to do it. It was a big public effort. We were all learning about permits, water usage, water access in our city. How are we all going to make this happen? And it was honestly one of the most warm community efforts that I've been embraced by since moving to Olympia, Washington. I found Trish Malone and in July started helping her build her mermaid tank, where I have, helped with painting it, the cost of the paint, pieces for the mermaid tank. And I spent time doing physical labor, like she said, in exchange for my PADI certification. Instead of making payments for the classes she provides, I was helping her build the tank, and then I would be performing with her in the summer and helping her again inside of her classes at the YMCA. That began in July. August was Olympia Harbor Days. That was the 28th, the 29th, and the 30th. I performed with her for free. She was allowed the spot at Harbor Days for free by the nonprofit organization. And we were allowed to have water access thanks to the Port of Olympia covering the service fees for us. It was a lovely show. It was honestly some of the most beautiful memories that I'll ever have. And I can't wait to continue to do that with my life. I think that that's my calling. Now, moving forward, I'm starting to volunteer in these classes where Miss Malone teaches at the YMCA. This is where things become a legal issue because PADI, who is the scuba board nationally that you get certified to scuba dive, free dive, and mermaid dive through, they have regulations that have to be met. And the witness that Trish brought today, how she said right before I began to speak, they had filed their own protection order against me that was denied by Kitsap County. Now, we're both volunteers at this establishment. Neither one of us get paid to do this. We're in the pool with these children, teaching them how to swim with their legs bound in a mermaid tail. However, I was new. I didn't have any kind of regulation from PADI to be certified or qualified to be in the water with these children. It's seen as a danger. I'm also not certified or qualified in lifeguard training through the YMCA or anyone else. And after I found out that I was breaking laws, rules, standards of national scuba, certification, I contacted PADI and I reached out to them and I said, I would like to understand what I'm legally allowed to do in the water and what I am not allowed to do, because I don't want to lose my certification to continue my career because I'm being misguided by the person I'm trusting to provide me a service. I made that phone call February 9th. That was the last day I saw Trish Malone. That was my 30th birthday. So I thought seeing my friend would be something that would be all right. We had the protection order and the harsh words from her witness happen. She told me weeks before that her father was on hospice. I did not know her father had died until I received it in her own handwriting on her protection order. And on the 30th, I went up to the YMCA. I hugged Trish and I said, hey, nobody's words are more important than yours. If you didn't say it to me, I don't believe it. I wanted to make sure we are okay. I know that you're going through a hard time with grief. I'm here for you, my friend. And then I left. And then on the 11th, I find out that Orion, her witness, had filed that protection order. On the 12th, it's denied by Kitsap County, and on the 19th, it arrives at my house. And I'm shocked by the content.
Talk about that. That's not relevant. That's a different issue in a different court. So
yes, sir.
With what Ms. Malone has alleged.
Yes, sir. So on the 21st of February, I get a phone call from the Olympia Police Department alleging that an employee at the YMCA is saying that I'm contacting their work to harass them. But when I received that protection order, the reason that I bring it up is because I was accused of a crime in that protection order that happened allegedly inside of the YMCA facility. Now, I reach out to the YMCA and I say, hey, I was accused of a crime here by one of your employees. May I please have the video surveillance footage to prove that I did not commit this crime? YMCA tells me you have to file an incident report and a police report. We're not allowed to give that footage to civilians. So I do. And that's when Miss Malone has said I'm contacting her work and harassing her. That was implications of the YMCA due to the accusations that were made by her and her friend in the protection order at Kitsap County. And that protection order, they say I made threats, that I was yelling and screaming and endangering children, which is a big deal when your job is surrounded by providing a safe, entertaining space for children. The police department, as of the 25th of February, hadn't maintained that footage. They weren't able to go get it yet. I don't know if they've obtained it since, but as of right now, I don't have access to it. If you guys do, that's unbeknownst to me. But that's why I'd reached out. But on the 9th of February, I blocked all social media accounts that had anything to do with the petitioner, the petitioner's friends, or family. On the 10th of February, I announced publicly on social media that I would no longer have affiliation with the company. And then I've had nothing to do with either party, anyone from the school. I let the people I was working with know, like she mentioned, I had reached out to other mermaids. I let the people that I was working with know we're no longer going to be working together, but you know, I'm still your friend, nothing wrong between us. I'm just going to part ways. There's nothing wrong with that. That's not illegal. There were also people mentioned, like Irish Fest, Thurston County. She didn't mention the fact that it was an Irish festival, and clearly by looking at me, sir, I think you can tell my genealogy is definitely Irish. The festivals that I'm working with are 501c3 nonprofit organizations. I will not be receiving compensation. This is a gift of love to my community, out of my husband's pocket, out of my free will and free time, out of my passion, that I'm providing for free. I have a handwritten affidavit you may have in the room with you now. I saw my husband had entered the courtroom yesterday at the event. She's wrong about that too. The event's not tomorrow. It was yesterday. I was a mermaid for free, talking to kids about ocean conservation. And that was strictly because of my heritage. I was reclaiming my heritage, making my redheaded grandmother proud, you know, to keep hold of something that is dying, my culture. And that's not wrong either. And it's certainly not something that I'm ashamed of or feel remorse or regret for, because I had a good time and those children had a good time. No one got hurt. And I'm so sorry, but her company is a Hawaiian themed mermaid company. The next festival that she's speaking of, the one that she's saying that she lost out on, it's Cascadia Ren Fair. Cascadia Ren Fair is a Gaelic and Celtic style fair where their actors actually learn how to speak Gaelic because it's a dying language, teach it to their kids, and do entire shows that are historically accurate in my dead language. You know, that's a beautiful thing. And I've got a handwritten affidavit from the co-director of that Renaissance Festival where she in her own wording states that they put out a call to action in the mermaid community, sourcing free mermaids. And the fact that I was Irish was a plus. And that's why I'm being brought on to that project as well. As for the insurance fraud claims, I have not performed for pay since January 1st at the casino that Trish mentioned. She paid me $165 on the 31st at 10:16 p.m. And that was the last form of payment I've received to be a mermaid to date. So also saying I wasn't her employee and that I've had nothing to do with her is a little outrageous when we've been in contact since June of 2025. We were in the news together. There's a news article, Jolt News covered Olympia Harbor Days, her mermaid school's right in written paper. There's proof that for months I've been working with her, and now, you know, I've even had to go through and apologize to the professionals that allow her to do her job because I was being taught incorrectly. I was being allowed to do things in the water, not only with my own body, but with children that put us all in danger because I wasn't the one permitted to be in the water. She's an instructor, not me. And I also have, if you don't mind, assistant mermaid instructor, Ono Wahine Aiena Mermaid School. Authorized to assist in mermaid classes, supervision, and safety support. It's just a piece of paper because none of that information on the bottom is true. I was not authorized to do any of that legally or otherwise. not by the facility that houses the school that she provides, not by her business, because I was not qualified, and not by the scuba association. So
At
I
this
wanted
point,
to.
Ms. Hagan, I'm gonna
Mhm.
stop you from further argument at this point or further testimony. I have pretty good understanding of what is going on here. Before I make
Yes,
my
sir.
ruling, I have a few questions for Ms. Malone.
Yes, sir.
Ms. Malone, when you indicated that she used your name and your insurance and then solicited any contracts, did you file a cease and desist letter of some sort to stop her from doing that?
I physically told her to stop using my name.
Okay. And you said that you have now lost contracts with such as Point Defiance and other entities.
Yes, sir.
Have you considered filing any claim of damages against Ms.?
No, I just want to be
Hagan?
left alone. So I want it to stop so I can just continue with my life and business.
I
don't like
understand
the
you're
legal
asking
stuff.
for a no contact order, which requires as Commissioner Stowell earlier indicated to all the parties present on Zoom and in seeking this type of relief, what course of conduct means, how it must show that there is an annoyance and a continued harassment to such a degree that it is causing substantial emotional distress to a person, to the petitioner. And then you also indicated earlier that she has been stalking you. You have given me some information, but what I have to find is that that stalking is that harassing conduct is being shown with the intent to frighten, intimidate, or harass, and a person knows or reasonably should know that the recipient will be intimidated or harassed. I have had the you have provided the information that she blocked social media so you couldn't see, but that is not harassment. That is not a stalking. You also said that she's making contact with third party and they believe they are being harassed. But I still have to make a finding to order a no contact order, which can subject a person to a criminal liability. I have to hear more evidence of continued annoyance, harassment as listed as elements in the statute. Do you have anything else to add before I make my ruling?
It's just that harassing me through third party, going to the vendors and, like I said, was using my good name to make herself look better, I guess, is how I can,
I understand
and
with your
saying
situation, and I think it is a complicated situation, but the relief that you should be seeking is not before court for in form of a no contact order, which subjects person to another criminal liability. If you have suffered any losses that can constitute a civil action against a person, you're free to explore into that. But I, at this point, am not finding by preponderance of the evidence that a no contact order is proper based on the evidence before me showing that the conduct is such that it seriously annoys a person, harasses, or is detrimental. It is definitely, I can understand it may have caused you financial losses
and emotional losses, sir.
and emotional distress and maybe reputation loss, but those are called tort law remedies that are available to you. So at this point, I am going to deny your motion. So we are concluded with this matter, and remaining matters will be handled by Commissioner Stowell. I'll sign off on this order.
Yes.
Catherine Marie Coleman and Devlin Chase Hill, case number 2018 DM 65. The movement in this case, Catherine Coleman, appears apparently in the office of Tina Huntington, her attorney. I noticed that there's another person present besides the client. Ms. Huntington, who is that?
That is my client's mother, Judge. Is it all
Her
right?
name?
Her?
Patricia Fee.
Patricia Fee.
All right. I noted her name in previous orders of the court. This matter comes before the court at this time for further proceedings in regards to a motion that was filed entitled Petitioner's Verified Motion for Immediate Modification of Parenting Time and for Child Support, for Judgment for Arrears, and for Sanctions. Okay, we've got a late addition here to our meeting. John Van Oschen, are you representing Devlin Hill?
That's correct, Your Honor. My apologies. I looked at the link on the original notice, and apparently there was a different link on the amended notice.
All right. Is your client with you?
He is not. I talked to him about 7 minutes ago. He was going to log in. So I'm going to check and see if I've heard from him since then. And I'm going to resend him the ID because he may have had the same issue that I did.
Ms. Huntington, were you aware of Mr. Van Oschen's involvement in this case?
I was aware that he entered his appearance, Judge, but I was quite surprised to get a response motion or response 2 hours before the hearing. I've not had an opportunity to review the allegations in there.
And I haven't seen his motion. I don't know when it was filed, but it must have been recent.
Your Honor, it's just a response to the motion that Ms. Huntington filed. She did inquire 2 days ago as to whether or not I was going to ask for a continuance, and I indicated that I was not.
All right. Counsel, summarize your response. Is it in opposition to everything that they're seeking, or what is the nature of the response?
That is correct. So reviewing the motion itself, the petitioner is verifying facts that would have occurred at the respondent's residence, which she would have no personal knowledge of. In addition, there are some counter issues regarding the petitioner unilaterally making decisions in violation of the joint parenting plan, enrolling the child in extracurricular activities to take the child out of state on the respondent's parenting time, and that also the child was involved in a car accident, and that the petitioner did not disclose that to the respondent when that accident occurred. It also asks that the court, because the parties are opposed, consider utilizing a form of ADR. I know that generally the local rule would direct towards domestic conciliation, although I know some of the other judges in the district are now favoring guardian ad litem over that process.
And so your proposal is what?
That because the parties are in opposition on this motion, that the court order them to ADR either through the domestic conciliation per local rule or appoint a guardian ad litem with the cost split between the parties, and that whichever way the court chooses to do that it be consistent with the local rules. So if a guardian ad litem is appointed, even though they're not covered on the domestic conciliation rule, that we would utilize the same procedure once a recommendation was submitted, in that either party would have to file a motion in opposition, and if not, then it becomes the order of the court within 21 days. That would be what we would be asking for today, Your Honor.
Your response to Mr. Van Oschen's opening statement, if you will, Ms. Huntington?
Thank you, Judge. Well, there's several in there. Yes, obviously my client's not at the visits, but she does get information from her child, and she does see him at exchanges. Judge, I don't know if the court has had an opportunity to look at the text messages, but he's extremely aggressive with my client. He calls her names. He uses foul language. He's posted reposted conversations with my client and with the child onto Facebook. He's talked about the case on Facebook. He set up a GoFundMe to represent him in this action. Judge, the co-parenting is just completely had a breakdown at this point. He has a history of drug use, and that's why we were asking that he submit to another drug test to see whether that's what's caused this deterioration in his ability to co-parent. I heard an allegation that my client didn't tell him about a car accident. She actually did. The child messaged her dad immediately and said, "We just got in a wreck. We hit a deer." My client was talking to the police officers when he starts messaging her saying, "You're violating, the joint custody rules. You're not telling me about this wreck." She was still on scene, Judge. So he's just extremely unreasonable. He interferes with my client's ability to put reasonable limits on the child's cell phone use. And then makes threats against my client when she doesn't comply with what he believes is appropriate for the child. We are not in opposition to the appointment of a guardian ad litem, Judge. My concern with the guardian ad litem is that it's not going to get us any resolution on the co-parenting issues and whether or not dad is back consuming illegal drugs at this point. So I know the courts and Butler don't always favor domestic conciliation, but that type of a person could cover all of these issues in one setting if the court would allow us to go that route. And then we have the child support issues, which we're not going to get resolved today. I know counsel's requested to exchange income information, and we'll look at that. But, based on our calculation, he owes about close to $18,000 in child support at this point, Judge.
Thank you. I don't see any reason we shouldn't be able to address this child support arrearage issue. A computation has been included in the paperwork submitted to the court, and I trust opposing counsels had the opportunity to see that.
Yes, Your Honor, and we're not denying that my client does owe back child support. That's not a denial. There's been periods where he's been unemployed, but he hasn't been able to make up all of the arrears. And this case is, as the court.
Okay, well, let's stop there. Let's stop there for a moment. Is there any error in the computation that was done on arrearages in this case that you need to bring to the attention of the court?
None that I could find, Your Honor.
Very well. Then the court will grant judgment for past due child support in the amount sought. I will recite that for the record. That number is $17,838.03. And that includes March of 2026 child support owed. Current arrearages, again, $17,838.03. Ms. Huntington, I'm going to ask you to journalize that arrearage amount. Submit that to the court for approval. Where does your client work, Mr. Von Oschen? I see he's now joined the meeting 10 minutes late.
He indicated he was having some issues with coverage in his area. Devlin, do you want to answer the court's question?
Yes, I am currently employed with AT Trenching. What I do is I work with utility companies to bury internet provider lines, and so I work with like coax and fiber and stuff like that. I'm a 1099 employee on my tax forms.
All right. How much money do you make at that job?
I'm making fairly good money, and I know that I'm behind on my child support, and I'm working to pay more on my current child support, as well as start to get enough money backed up that I can start paying significant chunks of that off, because it's one of my biggest concerns for sure.
Okay.
If so, figures wise, I have the ability to make about $2,000 a week. So 4 weeks, about $8,000 a month. If weather permitting and customers and companies, everything works out, that would be like a best case scenario. With it having been winter, I was on the lower end, around like $1,500 to $1,700 monthly income.
Right, we generally look at a full year's historical average, Mr. Hill. So
Right.
ups and downs included.
Yes, I've only been here about 5 months. I started at the end of the hot season with the company last year, and I've been doing really well. This is a very steady position for me. It's provided a lot of stability for me, and so I'm really loving my job, and so I want to continue doing well in my job and also using those funds to pay back these things, very important things like my arrearages and medical debts and stuff like that, so that I can get on current.
All right. Mr. Hill, you're going to be asked to provide some verification of your income, whatever documentation you have, 1099s, whatever it might be for the period that you've worked there, so that
Yes.
appropriate child support amounts can be computed and put into place. It seemed to the court that perhaps he needs to be under an income withholding order if there's going to be regular and consistent payment of child support in this case, with what appears to be a kind of an erratic payment record in the past.
I understand that.
You'll be working with your attorney based on some discovery requests made by the opposing party, Mr. Hill. I don't know that we're going to be able to settle that issue with certainty today, though the court just granted a judgment for back due child support in an amount just over $17,000.
I understand.
All right. Counsel, it's apparent to the court that either a guardian ad litem needs to be appointed to look out for the best interest of the child and do an investigation and make appropriate recommendations to the court, or the parties need to engage in domestic conciliation with an appropriate domestic conciliator. I've kind of heard from both sides here, and I don't think there's a clear consensus. Ms. Huntington, I'm concerned that domestic conciliation wouldn't be particularly productive if you believe that your client can't sit down with your client in a room at the same time and have reasonable discussions. Is that what you're suggesting to the court?
No, Judge. I'm not suggesting that.
Okay.
I'm just saying he's very aggressive about exchanges and through text messaging with my client. My client will participate in the same room.
And you don't believe that she would face the same aggression from Mr. Hill in that setting?
I do think she would.
All right. It's obvious to the court that communication between the parties needs to improve. Seems like this is a classic case for the use of a parenting app. I don't know if there's any movement in that regard. That has avoided a lot of communication problems in past cases that this court has handled. And the party should very seriously consider that right away.
Can I say something real quick on that, Judge?
You may.
My client actually signed up and paid for the Best Interest app, and she tried to get Mr. Hill to communicate with her through that, and he refused and he blocked the number. So she can't communicate with him through it, but she does have that. She's paid for it. It's available.
So how do they currently communicate, counsel?
Text messages.
Say that the majority of communication in my familial unit is not through text with the petitioner. My daughter informs me of a lot of things that I then try to facilitate conversation with Catherine in regard to joint custody agreements. And I don't feel that I'm being aggressive if I'm addressing something that I'm hearing third party from the minor child.
Devin, let me handle this piece of it. Judge, I'm not familiar with Best Interest. This is the first time I've actually heard of this particular app. and I know that counsel has expressed some concerns about both parties' ability to pay for stuff. I don't know how much this app cost. I know that for communication, apparently this one cost, Our Family Wizard cost. Talking Parents and App Close, I think, are still free to communicate. It's all the other pieces that you can no longer utilize for free. So, you know, I'm not opposed to a co-parenting app. Obviously, it helps everybody involved, including Your Honor, if we've got transcripts, because nobody can monkey around with the messages on there. They're kept on a third-party server. I'm sure Your Honor has seen that happen with text messages and emails and even audio and video. So we're not opposed to using a co-parenting app, Your Honor.
Ms. Huntington, I'll just suggest what I think you would have done anyway, and that is provide whatever information you have regarding the best interest app to Mr. Von Oschen and let him discuss that with his client. Obviously, the court is heavily favoring communication between the parents through this type of app. So the sooner we can get that in place, the better. Again, the court believes that communication between the parents generally would be facilitated by this court's appointment of a domestic conciliator, so that the parties can sit down and try to discuss what changes, if any, need to be made to the parenting plan, which is in place, which I think has been in place since the decree was entered years ago.
Correct.
I don't think that there's been any updating of that parenting plan, and I have no doubt that some circumstances have changed. So I'll take suggestions regarding an appropriate domestic conciliator, counsel. Ms. Huntington?
I would say Melissa Meyer, judge here in Sedgwick County. Another suggestion would be Stacy Ortega.
I have no doubt that Mr. Von Oschen is familiar with both. Do you have an opinion here?
Your Honor, I know that from a cost perspective, that the collaborative success has tended to cost people a lot of money. I would say the recommendations are like almost overly thorough, if that could be the case. But generally speaking, they're okay. I know that at one point that the court there was utilizing them. I know that at least one judge has quit utilizing them. Stacy Ortega for me is an absolute no. I've had experience in the past where she's interjected personal opinions of conduct of parties that was unrelated to the child custody into her domestic conciliation. She got into some religious issues regarding people living together, and I'm like, that's not really part of what this is about. It's about the people, not whether or not they're living together out of wedlock. The only other suggestion that I would have at this point would be Diane Sherwood. She does domestic conciliation. She also part of her she's no longer practicing law. Part of her practice now is helping people find peaceful solutions through learning forgiveness. She incorporates that into her domestic conciliation process. She's generally also very cost conscious, and she has a high success rate of mediating before we even get to recommendation. So that would be my recommendation, would be Diane.
Very well. Your position regarding Diane Sherwood, Ms. Huntington?
I don't know that she's even taking cases right now, Judge. And I generally would not select her just based on my past experience with her of being thorough. I think she gets tunneled into one area and loses focus. So that's my position. I mean, I guess counsel and I can talk and come to agree on someone else, but I know Melissa Meyer's group, they do a very thorough job, and that's one of the reasons that I wanted to have them considered. Some of the times individuals go to DC and we get back, if they don't resolve anything, we get back a DC recommendation that has no meat to it. We don't know what the basis was of their recommendation. So I have some serious concerns that we could be in that position coming out of DC on anything that's not agreed upon. As far as the cost, I think they do cost a little bit more. So I would be willing to talk to Mr. Von Aken and come to an agreement on someone else by agreement. But it sounds like none of the three that have been proposed are going to be agreeable.
Well, there are qualified people in the Wichita metro area that I encourage counsel to discuss and reach an agreement. The court will order the parties into domestic conciliation with domestic conciliator to be determined. Counsel, if you can't decide it, this court will. So again, I would give you a short amount of time to discuss it and make recommendations to each other. I want both sides comfortable, both attorneys comfortable with who is ultimately selected, because I want the process to work. And I don't want anyone to go into the process with some sort of chip on their shoulder about the person that's conducting it. So good luck in that regard. I have no doubt that with some good faith discussion, you'll be able to agree. I'm going to ask Ms. Huntington to draft the order for domestic conciliation, which of course names the agreed upon domestic conciliator. Submit that to the court. We do have a standard form that we've used in the past. You may be familiar with it, Ms. Huntington.
Yes,
so if you'll submit it on that form. Further, I need a good faith estimate from the parties as to how long this might take. I want to go ahead and set this case for review hearing outside of the time that you think that domestic conciliation should work, just so I keep this case on the schedule and to keep things moving. So your estimate of time, Mr. Von Oschen?
Well, Your Honor, normally we look at, about 60 days for domestic conciliation. I would probably, maybe be looking at maybe June just to be safe.
Any dispute with that, Ms. Huntington?
No, Judge. I don't know how far out you schedule, but if we get done earlier, could we approach the court for an earlier hearing if we
Yes.
need to? I think that's fine then.
Checking my June calendar. Do
And
you have
obviously, if we get a recommendation, it'll be covered by local rule. And so,
it would.
Yeah.
Counsel, if you check your calendar for the morning of Tuesday, June 16.
Judge, I'm embarrassed to say I forgot to bring my phone in to the conference room. Can I step out around the corner and look at a calendar?
You may.
Thank you, Judge.
I am available that morning, Your Honor.
Okay.
Just so we make it easy.
16. What day is it?
And again, that's Tuesday, June 16.
Judge, I'm wide open that morning, so that'd be fine.
10 o'clock a.m. Court will set this for status review. 10 o'clock a.m., Tuesday, June 16 by Zoom. Again, not precluding an earlier hearing if necessary. Counsel, if you're unable to agree on a domestic conciliator, which I believe you actually will, certainly communicate with the court by email as to what the problem is and what your individual choices might be, and the court will resolve the issue. I don't think we need a formal hearing unless you really want one. You can schedule it with my assistant, but I would prefer the email route, and you can communicate through my assistant, Mandy Stapleford.
Your Honor, I think we'll be able to find a reasonable solution between the two of us.
I have a high degree of confidence in that, Mr. Von Oschen. All right. All right, we settled the child support arrearage issue. Counsel are going to exchange some information, apparently with an eye towards setting a new child support amount based on now current circumstances. And we've got the parenting issues addressed through the court's order for domestic conciliation. So, Ms. Huntington, is there anything else that we need to address at this time?
Well, we had asked Judge for suspension of parenting time. I get the impression Judge is not inclined to do that, and I understand, but we did ask for that. In addition to that, I just want to make sure that my motion, it talks about the fact that there may be applicable Johnson sanctions here for failure to report income. So I want to reserve that for future determination by the court.
Noted, counsel. No, the court is not inclined to currently interfere with existing court-ordered parenting time, which actually, as I recall, was fairly limited for Mr. Hill as to what the actual court order allows. Anything over and above that is just, at this point, is going to be in the discretion of the custodian, which would be the mother in this case. The order is what it is. At this point, it has not been modified. The enforceable part is what's in the order, and I will expect the parties to follow it, pending further negotiations between the parties or further orders of the court.
Thank you, Judge.
But it would ask for the mother to consider some flexibility in appropriate circumstances. Okay. Anything else, Ms. Huntington?
Nothing further, Judge. Thank you.
Von Oschen, anything further at this time?
No, Your Honor, I have nothing further.
Very well. Good luck with the domestic conciliation, folks. I hope that you can sit down in good faith and work out the best possible parenting plan for your child through that process. Nothing further, then this matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Judge.
Thank you, Your Honor.
One and out versus Bert Swihart, 251636 and 24111. How many more do we have from the morning one? 1, 2, 3. We have 3 people left in the morning.
Yeah.
Is that who we have, Ryan or Bobby? Never mind. All right. And counsel, your appearance, please.
John Goldbach. I made on behalf of the slot.
Sir, your name for the record, please.
There's Your Honor.
All right. Today's the date scheduled for a probation violation as well as the pretrial, the final pretrial in this matter.
Has been finding pretrial, Your Honor, and we find when the 1636, Your Honor, I've had an opportunity to discuss this with prosecuting attorney. In fact, we reviewed this the last time we were here. I have also provided her with certain material, discovery material. We reviewed the video in this particular matter. Based on all of that, Your Honor, the people are offering to dismiss the R&O and to be responsible to the throat and be hit with. When this Mrs. Whiteheart, he understands that, and based on that, Your Honor, which please be in touch.
All right, sir, your attorney worked out a very good deal for you.
Thank you.
Please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
And you've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
I do.
You also understand by entering into a plea that you'll be waiving some of those rights. And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
You understand this could affect your probation that you're on, that you have a probation violation for on anyway, correct?
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And any immigration issues?
No, Your Honor.
And the court will accept your plea as knowing, voluntary, and factually accurate. Dismiss the original charge per the plea agreement. That's $250. Do you have that to pay today?
Not today.
This has been pending since November, sir.
I lost my job December 16th, and my hearing was twice now has been rescheduled. It was the last hearing was the 14th, then rescheduled to March 20th. I'm sorry.
Can you pay $50 per month?
Yes, ma'am. 100%. The 30th, I'm waiting on my taxes. I filed my taxes over a month ago.
Okay, and then you're paying it off in full?
I would like to pay off most of it fully, yes.
Okay, well, I'll just indicate $50 per month beginning March 31st. If you can pay more, you can pay more.
Thank you so much, Your Honor. Thank you.
All right, and then, but we still have the, probation violation to handle. You're currently on probation for domestic violence in this matter. It's alleged that you failed to register for domestic violence classes. You tested positive for alcohol November 14th of 24, and there's harassing contact with the victim. Incident report from the Trenton Police Department. And this was actually scheduled back in January, on January 9th of 2025. However, your client failed to appear, so a warrant's been issued for a very long time. And so you were not contesting the first two counts, and we set this for a hearing on the third allegation regarding the contact.
That is correct, Your Honor.
All right.
That's correct. In fact, we were here to address that. I'm here.
Right.
And we have never, and we've reviewed that. In fact, we indicated that he failed to appear. I'm not aware of that. However, I've been involved with this for a couple of appearances. So, and he's always maintained that. He's always maintained that, yes, he was guilty on the first two. There was a reports that were made, contact. However, he was not the instigator. And in fact, the reports exist. There's no doubt about that, the contact. However, he was not responsible for it. That's the reason why we're contesting at least that issue, particularly in light of the recommendation.
So I'm not sure, counsel, what are we doing? Are we holding a hearing on the third count? What are we doing?
I guess I don't know. I tried to explain that to the court last time when we were here. And the court said, well, I guess we'll have to have a hearing.
Right. So that's what we're
pleading guilty to the.
Is he pleading guilty to all three?
Well, it exists, but he wasn't responsible for it.
Well,
someone else.
What do you mean someone else was responsible?
The harassing without his knowledge and without he didn't instigate the third party contact.
Well, counsel,
It's there. We do not dispute that somebody sent these texts to the victim in this room. But that was not Mr. Swihart, nor was it at Mr. Swihart's direction. In fact, he has told her on numerous occasions not to have any contact with the showman.
Who did he tell that to?
The person who texted.
Which is who? I don't know who you're talking about.
Oh, I'm sorry, it's in the report.
What's her name, sir?
And this has been years ago. I don't know. I haven't had contact and it's been over a couple years, or the 24 to 25.
Okay, so counsel, I need to know what it is we're doing.
Right.
What's he doing? Is he pleading guilty to all three counts? Is he pleading guilty to two counts? What are we doing?
Well, he's pleading guilty to count one, count two. I mean, it all depends on the court, Your Honor, if I may. It says harassing contact with victim per an incident report from the Trenton Police Department.
All right, we're going to proceed with counts 1 and 2. I don't have anybody here to testify regarding the incident report. You can't just take an incident report. I don't even know if I have an incident report.
Well, there's a
But you blocked him. I don't know. So. Please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
As to counts 1 and 2, sir, the allegations in 1 and 2, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, sir.
And you understand all of those rights.
Yes, Your Honor.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
100%.
And you gone over your advice of rights for probation violation purposes, correct?
Yes, Your Honor.
You understand the recommendation here, sir. That's recommendation is that you're under advisement status be revoked, your probation be revoked, close the case without improvement, $50 probation violation fee, serve max days jail. Do you understand that's the recommendation?
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No, ma'am.
Ma'am, that's not how you sit appropriately in court, please. Counsel, you can please order your client.
Thank you. Mr. Swire, you were placed on probation to this court some time ago. Is that correct?
Yes.
And some of the terms and conditions of probation were that you were to register for domestic violence classes and that you were to test for alcohol and drugs as required. Is that correct?
Yes.
And did you fail to register for the domestic violence classes?
I started them. I did not finish them.
But my
Oh,
question
no.
was-
Sir, the question is, did you register for the classes?
Yes.
Okay.
Well, then why are you pleading guilty?
Oh, good. I never finished them. I never finished the classes.
The allegations you failed to register for the DV classes.
Oh, I apologize.
And I thought there was in
Yeah,
reviewing.
with everything going on with all the time, and we didn't get to talk that much in passing. What about
You, and I believed, Your Honor, that reviewing the report initially, that he failed to immediately register and then didn't go and register. So,
I don't know. It says failed to register for DV classes. Doesn't say failed to immediately register. It just says failed to register.
okay, so you did register.
I did.
And did you start the classes?
I did not start the class. I did. I talked to the lady, got everything set up, and that's what it is. Okay. Sorry about that.
So you didn't register.
No, I set the meeting up and everything like that. And
Did you pay the money to register for the classes?
I did not.
Okay, then you did not register.
I'm sorry. I'm
We don't- So you didn't pay the money. You set everything up, but then you didn't follow through.
Yes, I'm so sorry.
And did you test positive for alcohol on November 14th of 2024?
Yes, sir.
And the defense is satisfied.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the first two counts. The court's going to dismiss count 3 as no one's present to testify, and counsel adds to the recommendation.
That's the recommendation, Your Honor. These were his first violations, 1 and 2. Clearly, the recommendation is based more on the alleged harassing contact. I'm asking, first of all, that he did not revoke his under advisement status. Also, Your Honor, that he be required to attend the classes, register, and successfully complete the terms and conditions of probation. I don't believe that under these circumstances, Your Honor, that incarceration is mandatory.
And what are these circumstances? Your client was convicted of domestic violence
Stand, Your Honor.
by way of a plea.
And
This court sentenced your client to probation.
I agree, Your Honor.
He violated probation by testing positive for alcohol and for not attending, not even registering for domestic violence classes. And then he failed to appear for his probation violation, and there was a warrant out for his arrest for nearly a year. So what are those circumstances, counsel, that this court should not adopt this recommendation?
Well, I feel, first of all, Your Honor, that as far as the failure to that appear the first time, I'm unaware of that. First time,
This was scheduled for January 9th of 2025. He did not appear. The warrant issued January 15th. The warrant of 25. The warrant was recalled December 3rd of 25. I believe your client may have walked in.
No, Your Honor.
No, he was taken into custody.
And that was on this matter, Your Honor. The one that we.
I understand that. So he didn't even turn himself in. He ended up being arrested on another matter. And then that's how this ended up coming forward because your client absconded. So why, counsel, should I at any point even consider having your client back on probation?
Hold on a second. No, can okay, finish. Yeah, wait, sure. No.
You're saying here, I made all three overnight.
Well, since you have you done any other thing else? Have you paid your cost of fines? Have you done other things with?
We were just discussing that.
Oh, okay. Yeah. Your Honor, I think that I agree with what you're saying that he didn't.
Did you attend, I'm sorry, counsel, did you attend any outpatient substance use counseling, sir?
I did, yes.
Okay.
I did that for about a year and a half. Well,
Okay.
a little over a year, I should say.
Well, also, counsel, when I sentenced your client, I ordered mandatory incarceration for any violation. So the court's going to adopt the recommendation. The court's going to revoke your under advisement status, revoke probation, close the case without improvement. And the court's going to order 60 days jail.
I believe that the 60 days is excessive. I understand.
Well, the max jail, counsel, would have been 93 days.
I know what max would be, Your Honor. However, for the first two violations, those that he has found guilty of, not some deceived harassment.
I understand.
And I understand that, Sean. But 60 days for a first time for violation, along with the revocation, I believe is excessive.
Okay, and your objections noted, counsel, but let me just state for the record that your client was convicted of domestic violence. He did not register for his classes, none of them. Then he absconded for nearly a year, and I couldn't even at that point address this matter with your client. He also tested positive for alcohol while as a violation. And this court ordered mandatory incarceration for any violation.
I don't.
The court is not taking into account the third allegation because we're not even handling that allegation.
I understand.
However, the recommendation is max incarceration, max days in jail, max would be 93 days jail. The court revoked probation because your client didn't complete probation, and therefore the court's ordering 60 days jail.
And you've indicated any violation would be incarceration.
Correct.
I believe because of the violations that he was found guilty of, that max would clearly been, even if he was found guilty for all three of it, but clearly an appropriate incarceration, if the court feels it's necessary, and obviously it does, would be somewhere in the area of 5 to 10 days based on violations that he was found guilty.
Well, so counsel, what I'm doing though is I've revoked
I
probation
understand, Your Honor.
and
You've also revoked his unrevised.
well, hold on, here's what I'm going to do. This is probably the most procedurally correct way to do this. I'm going to order 10 days jail, 5 days for each violation. So that's 10 days total. The court's going to schedule this matter for a revocation hearing.
You're right. To be quite honest with you, I don't understand. The court has found and has revoked his probation.
Well, no, I'm going to hold a revocation hearing to determine then what the most appropriate sentencing would be after that. Because if I'm revoking probation, there needs to be some sort of consequence for your client other than just not showing up for probation. So that's what the court's ordering.
But Your Honor, the consequences of revoking probation and of revoking his under advisement status is just that. One, and more serious than the probation, to be quite honest with the court, is his revocation of the status of his under 769.48. That's his penalty. That's the main thing. Now, as far as the revocation of probation and the finding of incarceration for a violation, Your Honor, you set forth that you were going to give him, so if he violated probation, then there was going to be incarceration at the time of sentence.
Right.
All right. Now you've revoked probation and
Well, no. What I'm doing is I'm clarifying my ruling.
so you're taking 2 bites at the apple.
No, counsel, I'm not taking 2 bites at the apple. I've revoked the under advisement status. I'm sentencing your client to 5 days on each of the violations. That's 10 days jail. As far as the revocation of probation, that's going to be set for a revocation hearing. And then I will determine what's happening at that point. I'm not taking 2 bites at the apple.
So in other words,
That's going to be set for April 1st at 10 a.m. Because the statute indicates I need to hold a revocation hearing. That's how we're doing it.
Fine, Your Honor.
Thank you, John. Have a
You're
great day.
welcome. You're going out this door.
You're going that way.
All right, now we've got next in line, we've got Ms. Vasquez for Meta Platforms. And Mo, there you are, Hassan. All right. Okay. So you all have been here for at least one of the trials so far. So sounds like I'm sure you've got a picture of how we're proceeding. Yeah. So what I'll do first is go over kind of what I've viewed in the record. And then I'll turn it over first to Mr. Hassan to provide some testimony. And then I'll turn it over to Ms. Vasquez there for a response. And then Mr. Hassan, I'll give you a few moments there since this is your claim for some last words. So where I'm at is it looks like Mr. Hassan is claiming an amount of $10,000 owed on December 13th, 2025. Based on the claim, it indicates damages associated with, and there's some other comments, but it's summarizing damages associated with a wrongful account disablement that led to some loss of economic access and economic harm. In response to that, Meta Platforms uploaded a terms of use policy that I'm sure we'll get some comments about from Ms. Vasquez. So that's what I've been able to view from the file. So with that in mind, Mr. Hassan, if you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes, sir.
Okay, go ahead.
Did you, Your Honor, get a chance to read the exhibit list explanation that I submitted with it?
Let's see. Bring up your file.
It starts with an opening statement. It's
all right, looks like okay. So it looks like we've got a bunch of documents from you that were filed, at least uploaded today. Okay, so you can walk through these. These weren't in the files of yesterday, so I haven't had a chance to review these.
Okay, that's fine. I'll basically just go over it again. My name is Mo Hassan. I'm the plaintiff in this matter, and I'm bringing the small claims case against Meta Platforms regarding the permanent disablement of 2 Instagram accounts that I owned and operated. The case is not.
Well, and let me pause there, Mr. Hassan. So the court received this today. When did you file it?
December 30th.
Okay. Okay. And then Ms. Vasquez, the documents. So Mr. Hassan here has uploaded a number of documents. Is that something that did you get this before today? Are these documents you've been able to review?
I think we saw that Mr. Hassan sent something today, and we were able to look at it.
Okay.
They've seen the majority of the documents.
Okay. So all of the the reason I'm asking, okay,
they've seen all
because
of them.
So we can go forward today. That's fine. I want to make sure that both sides have full notice of everything that's been filed. So I can play catch up here through the file.
Yeah.
As long as Ms. Vasquez is comfortable moving forward with what's been filed, we can proceed today.
No, they've seen everything because they've responded basically to those particular emails.
Okay.
Yeah.
Is that correct, Ms. Vasquez?
Yes, we've seen the filings.
Okay. Well, all right. Thank you. I just want to make sure we're all on the same page. Go ahead, Mr. Hassan.
So again, this case is not about basically politics, ideology, or forcing me to host this concept. It's about procedural inconsistencies lack of transparency, and economic harm caused when large platforms like Meta basically can't follow their own standard frameworks. The reason I'm mentioning this is because I have several different accounts that I operate on Mo Wandering, which was established back in December of 2012. That's a public account focused on international travel. It's got over 9,000 followers. You can see that on Exhibit 1A, 1A1, and 1A2. That account is in good standing. Anyone can basically see it. There's no limits to the Instagram reach, and it's followed by minors because it hosts travel photos. That account is currently active on Facebook. Nomadic Husker was established in September of 2018. It's a private account that I basically use for international travel, but only for family that don't want other people to see that. That account is also active on Instagram. Husker Softball Network, that was established February of 2025, a little over a year ago. That is a public account focused on women's collegiate softball, followed by the Nebraska head coach herself and several players on the team. That account is currently active on Instagram and Facebook. Sports Couch Potato is a private account that I use for everything else to basically communicate with basically recruits and stuff like that. And then Chasing Volleyballs is another account that I also use for my own private use. Both of those two accounts that I mentioned, Sports Couch Potato and Chasing Volleyballs, those are all active on the account. Husker Volleyball Network is the one I'm talking about here. That was established in January of 2025 that focused on women's indoor volleyball. It had 11,500 followers at the time that it was disabled. It was tied to my Mo Wandering account, which again, like I said, it was established almost a little over 13 years ago. And it's also tied to my Facebook account, which has 80,000 followers on it. That's Exhibit 1, if you look at that, and Exhibit 1B. So the other account that there was
disabled. You may want to, just so everyone can hear you,
Sure.
the black box there, that's the microphone.
Oh, sorry.
Yeah, no, it's okay. It's just when it's covered, it's sometimes hard to hear folks. Go ahead.
The other account that made it disabled that I'm seeking damages for is Beach Volleyball Network. That was both focused on women's collegiate volleyball with 1,100 followers at the time of disabling. That's Exhibit 1C. Both accounts, Husker Volleyball Network and Beach Volleyball Network, published content exclusively related to women's volleyball, female athletes empowerment, recruiting visibility, and coverage of collegiate and USA indoor and beach volleyball. They served as an informational and promotional platform supporting women's sports. These accounts never ever contain any sexual content, graphic content, violent content, hate content, or political content. They were followed by several dozen Division I coaches, including Jamie Morrison, who just won the national title in collegiate volleyball, which I attended in Kansas City, Missouri, in December. It was also followed by several hundred Division I athletes, including players on Team USA women's national team. Some of the nation's top volleyball clubs, Legacy Volleyball, that won the national title for under 14, under 16 girls last year, along with Arizona Storm, who won the national title under 18. And I also collaborated with both of those clubs on several posts, along with high-profile powerhouses like TAV, SSCV, My Tribe Volleyball, NorCal Volleyball, etc. It was also followed by Love B, the co-founder Kevin Wong, who runs basically the Love B Professional Women's Volleyball League. He was following that, one of the co-founders. Media sports organizations like American Volleyball Network, Volleyball Magazine, Volleyball World USA, all of these accounts have over 100,000 followers, which I've collaborated with them on posts. These media organizations collaborate with me and other organizations like the NCA and FIVB, which is the governing body of collegiate and international sports. It was followed by AVCA, the American Volleyball Coaches Association, which I had shared collaboration posts with, recognizing Coach of the Year, High School Player of the Year. It was followed by PrepDig, the largest national recruiting website in the country, which I had collaboration posts on recognizing top high school talent in the country. It was followed by Under Armour itself, the actual brand, which hosts the yearly high school girls all-star, including their event organizer, Ziva Blackman, who is one of my followers, which had a few collaboration posts with her and videos leading up to the game in December before Meta disabled the account. This does not include any of the minors between 13 and 18 involved in volleyball that followed my account. Like I said, there was over 11,500 followers. Meta itself deemed my account safe for minors to follow without parental consent due to its content. You can see that in Exhibit 1-A2. If the court would find it helpful, I'm prepared to provide names and context of the accounts if they're restored or records are produced. However, because the accounts are disabled, I no longer have access to platform analytics or collaboration records. However, I can identify these relationships based on ongoing professional interactions that occurred prior to the disablement. If access is restored to my account, I can supplement this information. I know the court has no authority to order Meta to restore the accounts, which is why I'm seeking damages only. I've since the Husker Volleyball Network account was disabled, created a backup account called Husker Volleyball Network, and I'm submitting screenshots of some of these followers that followed me under the disabled account. If you look at Exhibit 2A and 2A1, that's Jamie Morrison, the Texas A&M head coach. Exhibit 2B and 2BA, that's Jennifer Oldberg. She's the Ohio State head coach and the current AVCA president. Exhibit 2C and 2C1, that's Brian Rosen, the Crane volleyball head coach who made the Final Four last year. Exhibit 2D and 2D1, Giovanni Malo, Oregon assistant head coach. Exhibit 2E is Maya Ogavugo, the top 2020 high school prospect in the nation. She follows the account. Exhibit 2F is Ayanna Watson. She's a member of Team USA national team and a current Pittsburgh University player who made the Final Four last season. Exhibit 2G is Layla Ostavar, member of Team USA national team and a current USC player. 2H is Legacy Volleyball, who won the national title in club for girls under 16 and 14. These, Your Honor, are just some of the examples of over the 11,500 followers that followed my account, not including Coach Danny Busman-Kelly of Nebraska herself, because like I said, it's Nebraska Huskers. That's Kelly herself, which is the top program in the country that other teams try to strive to.
Mr. Hassan, if I could just redirect you a bit. So sure. I understand you're kind of, sounds like you're laying a groundwork for your accounts being followed by lots of folks and all this. Can you, if you're able to tie in your testimony to
I'm getting to the timeline of disablement.
Okay, and the economic damage to that. Yeah, okay.
Timeline of the disablement. December the 12th, 2024, Exhibit 3A, if you look at that, Meta permanently disabled Husker Volleyball Network citing account integrity. I want you to keep that in mind. Without identifying any specific violation, 3A and 3A1. December 25, 24, Exhibit 1C, again, Meta permanently disabled Beach Volleyball Network, again citing account integrity without any explanation. No prior warnings were issued, no specific content was identified, no violation history was provided, no opportunity to correct or respond was offered before permanent disablement. I was informed that no further review was available and that my account data would be permanently disabled. I've made every good faith effort to resolve the issue, including opening multiple appeals. You can see that in 4A through 4A5. I contacted the Washington State Attorney's Office, and you can look at 4B. There's a file number in there. Basically, them trying to get involved. I contacted members of Congress, House Oversight Committee platforms. That's in 4C and 4C1. And I also spoke with chat agents on Instagram. The reason I mentioned this particular part here, Your Honor, this is why I'm seeking the economic damages. I received 2 phone calls from support agents, Exhibit 4D-12 and 4D-14. Under Exhibit 4D-12, you can see I spent almost 30 minutes on the phone with an agent informing that the account was reviewed by AI systems. This is directly them telling me, not what I'm speculating. They were basically told me it was reviewed by AI systems at the time. No human review was ever conducted based on the agent's research into the disablement, even after I appealed it, and due to the fact that there was nothing they could do, told me the only recourse possibly to get the accounts restored was legal action. The chat agent is the one that's telling me to file legal action against Meta. I informed the agent that at the time it was always going to be my final option. Your Honor, I don't have any evidence to support the conversation other than a screenshot of the calls, but the Meta agent told me that they record all phone calls, so Meta should have a copy of that recording. They made multiple barriers to support the contact support. The only way you can actually get a hold of support is actually purchasing a membership. So it cost me money to purchase that. There's where some of the economic damage is coming in from. The Meta subscription starts at $15 a month. That's a very basic one. Basically, all you can do is chat with an agent. If you want actual support, you have to pay the higher level one, which is $49.99 up to upwards of $4.99 for a subscription. So that's where some of the economic damage comes in. They've also obstructed data access obstruction. There's the economic damage right there. Meta publicly states that users can access and export their data. In practice, Meta allowed me to export data from my active Instagram account, but this would not allow me to download my information from all my collaborative posts from my disabled accounts. So the data export system does function. My credentials function. The obstruction only applies to disabled accounts. I want to get back to the account integrity and platform inconsistency. Meta stated that the disablement was based on account integrity, specifically alleging that users may not bypass enforcement by creating new accounts. Neither one of these accounts were created to bypass any enforcement. Both accounts were almost a year old. My Facebook account is linked to my Instagram account, which is linked through Meta's own account center. That's Exhibit 1, which has existed for over 13 years. If the alleged allegation was identity-based or user-based, the same enforcement would reasonably apply across all linked platforms. All my Instagram accounts and my Facebook accounts and my pages would have been disabled. Instead, they targeted these two specific accounts. My linked Facebook account and other pages, including Husker Volleyball Network on Facebook, has still remained active. Even though they've disabled it on Instagram, it's still remaining active on Facebook. That's Exhibit 7B-E. No explanation was provided why this selective enforcement was applied, why they disabled it on Instagram but not on Facebook. That inconsistency raises a reasonable question regarding how Meta applies this account integrity policy and whether enforcement is applied uniformly or with adequate factual basis. Now, I gave Meta an opportunity to respond back to this. Like I said, this was filed in December 30th of 2025. Meta did not respond back to me until March the 10th, stating that they need to know what these two accounts that I'm filing in the lawsuit. I sent them screenshots on March the 10th of the Husker Volleyball Network and the Facebook Beach Volleyball Network. If you look at Exhibit 11, you'll see that they went ahead and disabled an account called mattrule.rules. That was disabled the day after I sent them screenshots. It took them an entire week to respond back to me and saying the reason now that they're disabling the accounts is because of high profile impersonation. Didn't bother to give me an idea what the impersonation was until last night when they sent me a screenshot showing what the profile was. Now this account, sir, that they're talking about, mat.rules.rules, that's a parody account. That's just a meme account. I'm sure you know what that is. If you look at the screenshot of the actual, let me go back to it here.
If I may just take a minute
Sure.
to try and summarize where I think you're going.
Yeah.
Because I do want to make sure we have time to get over to Ms. Vasquez as well.
Sure.
So it sounds like you've got a number of these high profile accounts.
Mm-hmm.
They were removed or deleted, disabled, whatever the terminology
Mm-hmm.
is. You, according to the terms of use, you engaged with the help center,
Mm-hmm.
which kind of starts that process of
Correct.
disputing a deletion.
Mm-hmm.
And as part of that, accessing that help center to sort of make your case, you're saying you incurred some costs.
Correct.
And that's where that's from the economic damage comes from. Okay. And so now,
Well, that's one of them.
okay, that's one of them.
Yep.
And then, so you paid for the services in order to go through the help center
Correct.
to argue about the legitimacy.
Disablement, correct.
Okay. All right. And so at this point, what you're telling me is that some of your other cases, some of your other accounts were being deleted around this time.
Correct.
Okay.
Exactly.
Okay, go ahead. I just want to make sure I was.
So on like I said, on December the 11th, they disabled the account mat.rule.rules, which is, like I said, was a parody account. The whole purpose of that account was to basically just make fun of do you know who Matt Rule is?
No.
If you were to go on an Instagram account and you saw there's 2 followers on there, and the account specifically states in the bio, this account is to troll other people, would you take that account seriously?
No.
Exactly.
Okay.
So Meta is going to use that as an excuse, as their only exhibit of why they disabled the account, because I'm going to read basically.
Well, so I do want to, though, I want to focus on, I understand there's a dispute around, the deletion of the account.
Yeah.
You've talked about economic damages with respect to using the help center.
Correct.
You said that was some of them.
Correct.
What
The other one is, in order for you to monetize on anything with Facebook, you have to have over 10,000 followers. That's where the economic damage is. Once you hit $10,000, you can monetize on Reels, on posts, on shared collaboration posts. Once you do that, you can pretty much, that's where the economic does. It took me almost an entire year to build that 10,000 base follower. Once you do that, you can monetize on that. That's where the economic damage comes in from. And that's what the Beach Volleyball Network was also targeting, because that same network, like I said, the same account had 1,100 followers. It only had been around for about 8 months. I was trying to get up to that 10,000 followers.
Okay. All right. So I think so. If I can summarize again, then, and then I do want to turn it over to Ms. Vasquez,
Sure.
and then we will come back to you because I
Yeah.
know there's more you want to say. So it sounds like, again, correct me if I'm wrong, because I'm summarizing your argument here. You were attempting to, or had built up followers to that 10,000 amount in order to monetize on content.
Correct.
The Meta platforms moved to disable or remove these accounts. You engaged the help center in order to dispute those being removed or deleted, and incurred some costs there. And so now it sounds like you're articulating some reasons why you feel these accounts were deleted improperly. But the crux of the monetary issue here is that you're saying that if Meta platforms deleted your accounts improperly, then you're out monetizing
Thousands
some
of
these
dollars,
accounts.
correct.
Okay. All right.
Can I just read this last thing real quick? And
Sure.
then we'll
And
be
then
done.
a couple moments, then we're going to
Like I said, Meta disabled my accounts and they say the reason was account integrity, as reflected in my evidence. For the next 3 months, that remained the only explanation provided. Now, just days before this hearing, Meta has submitted new claim into the docket alleging high-profile impersonation, which is that Matt Rule account, that Mimi account. This is an ex post facto justification and rationale introduced after the fact to support a prior decision. If impersonation were truly a basis for the enforcement, it should have been identified at the time the accounts were disabled. It was not. I was never notified of the impersonation claim until last night, and I was not given any opportunity to respond to cure any alleged violation when it actually mattered as of last night. That latest admission to this docket is therefore pretextual, does not reflect the original basis for the enforcement, but instead appears to be a justification constructed after the fact. Additionally, Meta has not established a clear causal connection between my accounts and that particular account because they had nothing to do with each other. Neither one of them linked to each other. Neither one of them mentioned each other. And the disabling of my separate accounts. The lack of nexus further undermines the credibility of their position. Even if Meta has discretion under its terms, that discretion must be exercised with procedural fairness. Here, the shifting rationale, lack of notice, and timing of this new claim deprived me of a meaningful opportunity to respond. Your Honor, the sequence of events shows inconsistency, lack of due process, and a retroactive attempt to justify harm that was already occurred. For those reasons, I'm seeking those appropriate compensation for the damages.
Okay. Thank you, Mr. Hassan.
Thank you.
All right, Ms. Vasquez, over to you. If you could please raise your right hand.
Yes.
All right, do you swear affirm the testimony you're about to provide is the truth and the whole truth?
Yes, I do.
Okay. And then just so you're aware of what I'm looking at too. So I have your exhibits up. So if your intent is to kind of walk me through some of the terms of use and things of that nature, you can give me PDF page numbers and I can follow. Yeah. So go ahead.
Okay, sounds good. So just some background from our end. The plaintiff is a user of Instagram, which is a free service that Meta owns and operates. As a condition of signing up for Instagram, just like any other user, the plaintiff agrees to the Instagram terms of use, which is a written contract that governs the plaintiff's use of Instagram. And this is our Exhibit A. So the plaintiff alleges that Meta wrongfully disabled their accounts. After receiving service of the plaintiff's complaint, Meta looked into the claim, but the plaintiff did not provide identifying account information in the initial claim. So we reached out by phone call and later received account information for 2 accounts, which was Husker VB Network and Beach VB Network. Through human review, we confirmed that it had disabled plaintiff's Instagram accounts because one of their accounts violated community standards for authentic identity representation by impersonating a high-profile individual, namely Nebraska football coach Matt Rule, through the Instagram account at matt.rule.rules. Meta is not liable for the $10,000 in damages that the plaintiff seeks because Meta's disablement of the plaintiff's account was justified under the Instagram terms of use, which bar the plaintiff's claims and specifically disclaim the damages that the plaintiff alleges. So now getting into the exhibits. Sorry, go ahead.
I think it would be helpful for me if you could point me to where in the terms of use you're saying Meta disclaims those types of damages.
Yes, sorry, we're getting into that.
Okay.
Yeah,
all
we're
right.
getting now.
Okay.
Start getting into all of our terms of use and whatnot. So first, Meta had the right to disable the plaintiff's Instagram account for violating the Instagram terms of use. So this would be at our Exhibit A, page 6 of 9, section 6. So under the Instagram terms of use, the plaintiff authorized Meta to remove any content if Meta believed it violated the terms of use, Meta's policies, or its community standards. The plaintiff also agreed that Meta could refuse to provide or stop providing Instagram to protect Meta's community or services, to mitigate Meta's risk or legal exposure, or if the plaintiff violated Meta's terms of use, policies, or community standards. Again, this is at page 6 of 9 at section 6. So now to jump over to Exhibit B, this would be our community standards for authentic identity representation at page 2 of 3. So the Instagram community standards for authentic identity representation in effect when Meta had disabled the plaintiff's account prohibited accounts that impersonate another person. The Meta policy on impersonation also states that if you intend to parody, express support for, or show interest in another person or business, you must make it clear to others that you do not represent and are not authorized to speak on behalf of that person or business. You should, at a minimum, ensure that the name, bio, and username of your additional profile make your intentions abundantly clear. This is our Exhibit D now at page 1. So into the specific violation, the plaintiff violated this community standard by creating a parody account of Nebraska football coach Matt Rule through the Instagram account at matt.rules, which did not follow Meta's guidelines. Therefore, Meta was justified in disabling this account. So this account was the source of the disablement for the other 2 linked accounts. And this account had the bio of Nebraska HC, so Nebraska head coach, with no attempt to assert that the account was not actually Nebraska head coach Matt Rule. Furthermore, a post made, which we submitted yesterday as Exhibit E, though I don't know if it was received. And we did share that with Mr. Hassan as well. But this would be a post made that shows a clear example of violating conduct where the caption was, "I'm Matt Rule. Welcome to my Instagram page. I use this account when I want to troll people and can't use my official account. Believe me, I'm Matt Rule." So on Instagram, it's very obvious that you simply cannot state that you are another person because it will violate our guidelines. So the plaintiff claims that anyone would be able to tell that it's an account that's not actually him. However, again, our policy on impersonation is clear. You, as the Instagram user, have the responsibility to make it clear that you are not the person you are claiming to be. This post and the bio in no way establish that this is a parody account. This itself presents a legal risk for Meta as well, as we cannot allow a high-profile impersonating account to continue on our platforms. So the plaintiff also claims that, or the plaintiff suggests that this account was the last one to be disabled. However, this was actually the first to be disabled. So based on our investigation, the Instagram user matt.rules was disabled on September 11th, 2025. The Instagram user Husker VB Network was disabled on December 12th, 2025 for account integrity. And Instagram user Beach VB Network was disabled on December 25th, 2025 for account integrity. Now, just for context, linked accounts are not disabled until our team can positively confirm that the accounts are linked together. So that's why they wouldn't all be banned at once or disabled at once. And while investigating, our team may interact with the disabled account and can temporarily re-enable the accounts to review data. However, that doesn't mean that the account was wrongfully disabled. It just happens to be that our investigative team is going through the data. And this could explain the March 11th disablement notification, as our team was conducting their investigation at the time. So further, under Meta's account integrity policy, which is the main point in the plaintiff's claim, Meta reserves the right to disable accounts that are owned by the same person as the offending account. So this is at our Exhibit C at page 2. Although the plaintiff makes reference to the other accounts, these were rightfully disabled as well because they are linked to the offending account. The plaintiff's claims that we are shifting reasoning for disablement is incorrect. Meta uses account integrity notification as a catch-all sort of notification for certain violations, namely when an account has linked accounts and those are being disabled for violating. The volleyball accounts were disabled for being linked to a profile that violated our standards on high-profile impersonation, thus making the volleyball accounts disabled for integrity violations. So the plaintiff also claims that other accounts are linked to these accounts, but our team was not able to confidently link the referenced currently active accounts with the deactivated accounts. In fact, our team did not review the active accounts because we were unaware of them. They didn't appear to be linked to the disabled accounts or the violating account on our end. This could be for reasons of different emails or phone numbers or different signals on the other accounts, but we do make a good effort to make sure that we could confidently link offending accounts with other accounts. So next, Meta is not legally responsible for any interruptions in the plaintiff's access to Instagram. Under the Instagram terms of use, the plaintiff accepts Meta's disclaimer of any guarantee that Instagram would be safe, secure, and work perfectly all the time. This is at page 7 of 9, section 7.3. And finally, the Instagram terms of use specifically disclaim the damages that the plaintiff seeks. So this would be Exhibit A, page 7 to 8 of 9, section 7.3. So under the Instagram terms of use, the plaintiff agreed to Meta's disclaimer of warranties to the fullest extent of the law and agreed to cap Meta's liability under the Facebook terms of service to the greater of $100 or the amount the plaintiff paid to Meta in the past 12 months. And also agreed to Meta's specific disclaimer of liability for lost profits, revenues, information or data, and consequential, special, indirect, exemplary, punitive, or incidental damages. Here, the plaintiff's consequential damages for economic harm are disclaimed. So the Instagram terms of use specifically bar such damages. Additionally, the plaintiff has not produced evidence to us that they lost $5,000 for each of the accounts, and the plaintiff seems to ultimately be seeking an arbitrary monetary amount for having his accounts rightly disabled. And just to tie it all up, Meta's its own private company with its own enforcement policies, and when you sign up for Instagram, you're agreeing to the terms of service, the terms of use, where you know that you have to abide by our guidelines. And given that the plaintiff did not abide by our guidelines, the accounts were rightly disabled.
Thank you, Ms. Vasquez. One follow-up question for you. So just so I get the timeline right here. So it sounds like Mr. Hassan engaged, so I'm looking at section 6 of the terms of use. It's on page 6, I believe, of Exhibit A. And it outlines it says there in the first paragraph, if you believe your account has been terminated in error, or you want to disable, or you want to disable or permanently delete an account, consult Help Center. And then, so is there a if an account gets disabled and somebody wants to dispute that deletion, I understand apart from the arbitration clause, and I know there's a carve out for small claims. Is there a dispute process like through the Help Center that folks use?
We do have an appeal process in place. Usually when accounts are rightfully disabled, they're not going to get much help from the Help Center if our review proves that that the disablement was justified. But there is an appeal dispute that people can use.
Okay. And did Mr. Hassan use that process in this case? Are you aware of?
I'm not aware of that. Yeah.
Okay. Do you know, is that part of your exhibits where that it's talked about that there's that internal appeal process?
I don't believe so. I don't believe that it's a part of our own exhibits.
Okay. And I don't expect why it would be if he didn't utilize that.
It's in my exhibits, Your Honor.
It is?
Yep, it's under exhibits 4A through 4A-5. Multiple appeal attempts. In fact, 5 cases in total.
Oh, those were the appeal attempts here.
Yep. Each with a different case number.
And what was the result of those appeals?
They basically went on like I said, they just basically told me they're reviewed by AI systems and they couldn't do anything about it. Because when the first time I appealed it, my account was basically said that this is final decision 2 hours later. Mm-hmm. Within 2 hours, that decision was final.
Okay. So Mr. Hassan, okay, thank you for that. So back to you. I have a couple of questions for you.
Sure.
So the claim here is I'm going to focus on it being grounded in a contract. I understand you're making sort of some larger claims about procedural fairness and things of that nature. What I need to do though is this is small claims court, and the $10,000 you're requesting need to be grounded in a claim that there's a breach of contract, and the contract at issue here is that terms of use. And so a couple of questions for you.
Sure.
Let's see. So you went through the appeal process, and those appeals were denied.
Mm-hmm. Without ever got to get an explanation why the accounts were disabled.
Right. Okay. Do you have any response to Ms. Vasquez's position there that as part of the terms of use, you are sort of disclaiming the types of profits that you're seeking that you're not getting by getting the claim.
One thing that she mentioned is that she herself acknowledges this was a parody account. She said that anybody that would see this account would notice it's a parody account. They're using the justification that just because I did not label it.
Right. So I want to stop you there. So, and I understand this can be splitting hairs maybe a little bit. This is not, I don't want to get into whether the accounts were correctly or incorrectly disabled because, that it sounds like there is an internal process for Meta platforms to review those and go through that process. What I'm focused more on is, again, that this contract where part of signing up for the service is disclaiming certain types of damages, including lost profits.
Correct.
And so that's to be honest, that's a part that I'm focused on here, looking at this as a contractual dispute. And so I understand you're saying you think that Meta made the incorrect decision on terminating your accounts, even if that's true. Do you have any response though to the idea that as part of signing up for the service, you signed a terms of use or agreed to as terms of use that disclaims liability for lost profits, even if it's wrongfully terminated? Do you have any response to that?
I do. Basically, the arbitration clause states that they have to do it within a consistent manner, and they did not do it in a consistent manner there. So the arbitration clause regarding the $100 settlement does not matter at that point there.
So that's where you're saying because they do this inconsistently in your view.
Correct.
They've sort of violated they violated the contract by not doing this consistently.
Which is the reason why I submitted Exhibit 12 in countering to her response basically about the head coach there, because she said that the accounts have to specifically state on there that they're parody accounts. Exhibit 12, if you look at on that is a person claiming to be a paternal twin of Kendall Jenner. That's a parody account. Right. Why is that account with 1.2 million people not banned? Mm-hmm. If that's their legal basis, why is that an ad account? Because it's a verified signature account by a comedian, but it should still state on there that this is a parody account. So why would you target me, not target them?
If you have it, I know you've got a lot of exhibits.
Yeah.
The consistency sort of in enforcement. Are you able to point me to that in the contract?
Let's see here.
And if it helps, I think you may be circling around 7.4 of the terms of use, how we will handle disputes. That's at least Meta's Exhibit A at 8. I think we're not in the arbitration clause,
correct,
to be clear, but that's where they talk about handling disputes. So if there's something in there you want to point.
Well, the inconsistency is that they saw that my account, Husker VB Network, is tied to my actual Facebook account, which is tied to my actual Mom Will Wander account. The Facebook account is basically the main account there. So if I had basically did something wrong that was identity based, those two other accounts should have been banned at the very same time. That's the inconsistency right there. You can't pick and choose one account. I mean, those two accounts, yes, were linked to that, but the Husker VB Network is the only one that's listed under my account center. So if you go under Facebook, both of those accounts are my two main large accounts. You can't just ban one and leave the other two.
So again, what I'm having trouble getting past, I understand what you're saying.
Yeah.
Is again, even if you are ultimately successful in claiming wrongful termination, there's still a contract that says by utilizing the services in the first place, you're disclaiming certain types of damages, correct, and including lost profits. And so that appears to be the basis of your request, is loss of the potential monetization based on followers.
Well, the reason for mine is basically not only is it for the loss of established audience and engagement, but it's also loss of promotional and monetization opportunities, loss of goodwill and professional credibility, disruption of relationships with those clubs and volleyball organizations, and time expense spent attempting this resolution. Those were my damages right there.
Right, and so you would have to. So I'll cut to the chase. Yeah. So I'm going to deny the claim. You would have to demonstrate how that $10,000 specifically relates to those losses, and then why that's not loss of profit that's disclaimed in the user agreement.
But the only way in order to get damages basically is once you hit 10,000 followers. So once I hit that, I mean, that's when you start monetizing on that.
Right. So I think it sounds like you're claiming loss of potential damages,
Correct.
which is, I mean, that's a step removed even from if you were making money from your followers and the account was deleted, that's lost profit. I think you're a step removed from that even by saying you're arguing for the loss of profits that hadn't been realized yet.
No, I had already started getting profits from that. That's what I'm saying.
I'm trying to say those are essentially they're the same, they're a different degree but same category. You're saying that you were entitled to certain profits that you didn't get because your account was disabled, and you're saying, well, it was disabled incorrectly. And my response to that is, based on the contract, you've agreed to hold Meta harmless for lost profits. And so on that basis, I don't think there's been a breach of a contract here entitling you to $10,000 for lost profits. All right. Do you have any questions, sir?
No.
Ms. Vasquez?
No questions.
Thank you, ma'am. You're free to go. And sir, thank you for being here. I understand this is not the result you were looking for, but it's the ruling today.
Thank you. Bye.
My goodness. Stillwell's wrapping it up and I'm still in chat, not paying attention that the show's over. Ladies and gentlemen, not even ready for it. It happened too soon. It went by too fast. What can I say? Should have known better. The one who put it together. But hey, there's good news. In just about 7 hours or so, we'll have a premiere and another hour and a half full of court. And tonight, ladies and gentlemen, it's a good one. Let me check out and see which one it is. Tonight we have Judge Webster. Pro se defendant rejects the plea deal. Let's go ahead and make that live right now. And ladies and gentlemen, you're going to see a massive pro se backfire from earlier this week. I think it was just from like Thursday, if I'm not mistaken. So come on by, hang out with me and chat while we have a hour and a half long premiere with Judge Webster and a couple of numbskulls that will make you almost pull your hair out. So get your tea, get your popcorn, get it all ready, ladies and gentlemen, and have a great rest of your Saturday. I'm going to go help Mama with some stuff that I'm sure she needs doing. And I'm going to hang out with the puppy dogs who are lazy on the couch right now. They've been running around all morning while we were having the live stream, driving me crazy. But ladies and gentlemen, we got lots more content coming out for you. We'll be dropping a couple of standalones every day, and then we'll be doing the daily case review every night at 8 p.m. Central, just like we do every single night of the week. I am your Lone Wolf Whistle. I am your host for these here little court compilations that we do every single day of the week, almost, except for Sunday. And I am your curator for this here archive at the Court Gallery. Thank you so very much for hanging out with me. Thank you for being in chat. And Zach, thank you so much for your contribution today, my friend. I am your Lone Wolf Whistle, and for now, I am out. Thank you, Eileen. Thank you, Jerlay. I don't even know if I say your name right half the time. Becky. Katie, I know you're out there. Kiernos, thank you. Barry, thank you. There's a lot of people I don't know how to say names. Mama, I know how to say your name. Thank you, Mama. Romiticus, thank you for hanging out today. Math Girl, great to see you as always. Barry, Becky, Granny, I know I said your names already. Tev, I didn't say your name. Alex, thank you so much for hanging out in chat. All you lurkers, thank you for hanging out also. We'll talk to you later. some people have no idea what they're doing. And a lot of them are really good at it.